Okay, let's see. Okay, let's go back over here. Can you hear anything? Okay, let's go back over here. Can you hear anything? Okay. I'm trying to figure out how to get the visual here. Let's see. Sorry about this. Can you hear anything? Let's see. Okay. I'm trying to figure out how to get the visual here. Okay, well that's good to know. If this doesn't work, I can do it on the other platform. It's just I've got to shell out $120 to do it. So, let's see if I get this. Stream your in a web browser. Okay. I think. Nope, that's not it. Oh gosh, this is so frustrating.
Awesome fortune.
Trying to pull up the image. Have they started? Let's get the audio playing at least.
Did you know that Alex was spending $50,000 per week supporting a drug habit, presumably through Eddy Smith, and that he owed money or he was indebted? So Mr. Griffin introduced the relationship between the defendant and Eddy Smith. The court conducted a pretrial, a hearing outside the presence of the jury, addressed the issue, made it clear that the roadside shooting was a bridge too far. Then the defense decided to build a road over that bridge, decided to just go right there as if they could dance through fire without getting burned, scarred, or anything. The door was open. This is not the same as the situation in State v. Hayward, where a co-defendant's, a cooperating co-defendant is being questioned about unrelated matters, totally unrelated to the case, and the Supreme Court presiding judge went too far in allowing evidence not proportional
Let's
to
see.
what was open and which he already ruled should not have gone, should not be introduced.
Using
I
the
find
YouTube
that
software. I'm
what
just not
this
sure how
court
to add
allowed
the,
on yesterday was
video.
proportional
So,
because it was in
just a minute.
relation to evidence elicited not by the state but by the defendant. And the state is entitled to explore this relationship with between the defendant and Eddy Smith. And then we'll have further discussions at some point regarding this limitation of just randomly throwing out names of people or suspicions and speculations regarding on the issue of third-party guilt. But to the extent that the defense sought to introduce the relationship between the defendant and Eddy Smith, and then to seek to infer that Eddy Smith might have been or should be a suspect in the murder, then to prohibit the state from saying, well, if he's if Eddy Smith should be a suspect and Mr. Murdaugh, who at the outset engaged in his form of problem solving by telling the state what this case was all about and the murder was all about, meaning the boat crash, then later engaging what appears to be a conspiracy along with the person that the defense seeks to insinuate to be or should have been a suspect. The state is entitled to explore that. The extent to which the state should be entitled to explore that, that's open for discussion today, but not based on the court's ruling yesterday. The court in the Hayward case did indicate that the court should be careful as the nature and extent to which these other matters should be allowed to go into, and I intend to do that. But the record is protected to the extent that Mr. Griffin went through YouTube and citing what his version of what he said yesterday, excluding the portion that's more relevant and important to the court's ruling. But the record speaks for itself on all of that, and the court's ruling stands as it was given on yesterday.
Your Honor, obviously we would accept your ruling, but there.
Okay, now we have a ruling, we have for the record, now we have an exception to the ruling, and another comment. Go ahead.
So, what I'd like to discuss now is what the state will be allowed to submit in support of this position. Now, clearly there is a taped statement by Mr. Murdaugh from a detox facility in Atlanta, which was initiated by Mr. Griffin and I. So certainly there's no objection to that. I mean, there could be, but no real objection to that. Secondly,
no objection to the statement.
Well, no objection to the statement pursuant to and conditioned by our previous objection.
Yes, sir.
To. I want to make the record clear. We're objecting to any of this.
Oh, I understand. You've objected to everything throughout the trial. I understand.
Well, there's a couple of things we missed. We'd like to rehear some of those, but Your Honor, but then, and again, Mr. Waters and I discussed last night after your ruling a way perhaps, I know this is shocking, to expedite this process. For instance, there is a statement made to EMS, the statement they're wanting to get to, which is, drive-by shooting, all those sorts of things, which he later on admitted in the telephone statement that was taken, was not true. We get that. He didn't need to be Mirandized on the side of the road by EMS. However, there are 2 recorded statements taken at the Savannah Hospital by Agent Kelly after he is, and we've got the medical records here if you want to look at them, but clearly has suffered a wound to his head, a fractured skull.
Always suspect of that word clearly and clear. Everything is in controversy.
I don't think this is in controversy.
Tell me what's clear again.
Bullet wound to the head, fractured skull, brain bleed. That's not contested. The medical records indicate medication that he was under while he was at the hospital. We would think there'd have to be a Jackson v. Deno hearing on those interviews, just under the issue of, was he competent, a competency hearing. To do that, we would have to bring the physicians and the treating physicians from Savannah here to testify. And again, and I think Mr. Waters will concede, it was at 6, I emailed him and said, all good, what we talked about yesterday, and he came back a little while later and indicated that he'd like to put those in. Mr. Griffin and I, over a cup of coffee, said there's competency issues, and we informed him of that this morning. Nobody's playing gotcha here. So we don't believe those should come in without Your Honor being able to rule that he was competent, hear from the doctors, and I think we may have worked out a compromise on that. I just want to confirm that for the record. But what we have worked out is this. The statement that he would not have to bring the EMS people. There's a statement that they made. Agent Kelly can publish that statement without having them need to be here. There was a knife recovered at the scene. They don't have to Kelly can identify that. There was a what else?
Your Honor, so what we talked about yesterday, just to kind of wrap this up, was again my intent to do this in a very expedited and focused fashion, not get into every detail or litigate that entire matter. And I suggested to the defense, and they agreed yesterday, that I could have Agent Kelly, who's the lead investigator on the side of the road, come up and essentially, in a very abbreviated fashion, walk through the case without the need to call the 911 operator or the ambulance driver or the roadside deputy or the DNA analyst or the person who found the knife, and so forth and so on. And I plan to do that, again, in a very expedited fashion. I'm not talking about anything 3 hours or the like. We also discussed this morning that I do need to be able to relate to the jury, though, the defendant's claim, which I have argued to you is particularly relevant, that he was attacked by an unknown assailant on the side of the road, when in fact he knew exactly who it was. He had actually arranged for it. And so our discussion that I thought we had an agreement on, I think we still do, is that Agent Kelly, there was an interview in the hospital on 9/4 and one on 9/6, and that I would have Agent Kelly just summarize and reiterate the defendant's claim about what happened on the side of the road, as well as the fact that he worked with a sketch artist, and show that sketch picture, and then just move through it like that. And then we will play for the jury, which I think they just said they don't object to, or no additional objection, the telephone interview in which he ultimately admitted to law enforcement in the presence of his attorneys that it had been a lie.
Yes, sir.
That's the deal. But I feel a little more comfortable if we could just have, and I'm not trying to delay court, but this recording is 47 minutes long, 41, whatever, 40 plus. So many recordings, I'm confusing them, but 41 minutes long. Could we take, if you could just, and by the way, I've agreed to allow him to lead unless I see something reprehensible going on, which for me is difficult to restrain myself from objecting, which would expedite it even more. But at 6:30 this morning, we were not in a position to discuss what Agent Kelly's, the sort of acceptable, what happened at the hospital thing. I'd just like 5 or 10 minutes just to review that with him, and then I think we're on go. Although, just for the record, we're objecting to any of this. I don't want this kumbaya moment to be viewed as any waiver of our objections.
The only thing I just want to put on the record, again, is that in discussions with the defense counsel, moving expeditiously with Agent Kelly and without raising hearsay and that sort of thing and making us go through our paces has been a strategic decision that the defense has made.
Pursuant to the, I just want to make it clear, I hate to sound like a broken record, but I don't want any appellate court ever to look at this and say, well, you agreed to it. We're agreeing to this process pursuant to Your Honor's ruling this morning.
I have not reviewed any of the evidence that you all are now referencing. So to the extent that you all have an agreement on moving forward with this evidence, considering the objections, I'm fine with taking 5-10 minutes if that will expedite things. I deal with what you all disagree on, not what you agree on.
Yes, sir, Your Honor. We're going, if Your Honor, when you take this recess, we're going to take myself, Mr. Griffin, and maybe even Mr. Barber to, he seems busy, to a room where we can have some peace and quiet and have a discussion without being interrupted every 2 minutes.
All right. We'll be in recess then for hopefully about 10 minutes.
All right, remain in order.
Okay, he is resting for the moment, so
I'm sure when they went into this, they
set
didn't think
things
that they
up
were going to
here.
hear about financial crimes and now that about an alleged suicide and comments that were made
let's
by the
see.
defendant in a hospital. But that's what's going to happen. We'll take a quick break. We'll be right back after this.
Yeah, I just didn't anticipate this. I was going to do an experiment and ask Josh from the lab about how he uses um, Streamlab, but yeah, this is not it's not very user friendly for novice. So um, let's see. Okay, let's go for this now. Just need to enter all the oops, let's see. Got to make sure I get my numbers in right. Okay, let's see. I've got something off slightly here. Let's see. Okay, let's see. What is it? Oh, good. It sounds like it's, I don't have to pay for it all at once, so I'll be able to cancel it once I figure out something on another. So we're going to be good here. Okay. Okay, we're almost there. Ah. think it's day 19. Okay, I will edit some of this information later. Let's see. Create broadcast. Okay, let's see. Testing. Okay, looks like we're almost there. Okay,
And welcome back to Law and Crime, everybody. And
okay, let's see, where am I? That isn't it. Okay, let's see. Okay, we're going to end this one. I've pulled it up on another place, so let's just double check that we've got it. Okay. Let's see. Is it doing anything? Hello? Oh, okay. Hello? Let's see. Okay, we've got it. It's
Hello?
just... Okay, we're just switching over. So go back to my channel and pull up the other stream, and I'll end this one. Okay. All right. Gee, I'm not sure how to do this. Oh, okay. I think I know. Let's see. I don't know how to end this. Okay.